There are about 1 million people in the UK who are working on 0-hour contracts, and despite popular perception, these people do have a lot of rights as workers. So let's talk about the rights that they have and the rights that they don't have. The term 0 hour isn't actually in the law. Instead, what's in the law is the distinction between a worker and an employee. Workers have fewer rights in employment law than employees, but they still have a lot of rights. For example, all the laws relating to discrimination, the laws relating to whistleblowing, being able to not be disadvantaged because you're working part-time, your rights to rest breaks, all of those still apply whether you are a worker or an employee. Workers are also entitled to the national minimum wage, and they have the right to accrue holidays. And if they've worked for a company for more than 1 year, they also have the right to take the holiday before it has accrued. There are two particular things that only applies to zero contract workers. One of them is the protection against exclusivity. So if you are on a 0-hour contract with a company, they can't prevent you from working with other people. You have the right to go and get work anywhere else that you want to. The other one is that they can't guarantee that when they offer you the work that you have to take it. They don't have to guarantee that they will give you work, but equally you don't have to guarantee that if they offer you the work that you will actually do that work. That is called mutuality of obligation, and that is actually one of the 3 tests of what an employee is rather than a worker. So if you are on a 0-hour contract and that company is saying you have to take the work that we're giving you, then they're actually moving you towards a status as an employee, which gives you even more rights. And that's particularly dangerous because if you look at the other 2 tests for an employee, the first one is called personal service. It means that you can't subcontract out the work, you have to personally deliver it. And the third one is control. And that's where the employer takes a lot of control about how you fulfill that work. So if they were already ticking the other 2 boxes and then they insist that you have to take the work that is offered to you, then you could be classed as an employee and then get more rights and more contractual benefits. Those additional benefits just for employees includes things like maternity or parental leave, the right to be paid your notice, the ability to take time off for emergencies, protection against unfair dismissal, and the right to be paid for any redundancy pay. So make sure that you really are a worker and not an employee, and make sure your employer knows too.